Thank you, Professor Banks. There's been copious note-taking up here, and we could engage in a dialogue amongst panel members, but we've done this before. They've had their opportunity. One of the principal purposes of this symposium is to allow you, as attendees, to pose questions to these gentlemen. So why don't we proceed directly to that phase of the panel presentation. We have about 10 minutes for Q&A. So for those of you who have questions, pose them either to the panel as a whole or to individual panel members. Professor O'Connor.
I think you're picking up on the theme that Bill Banks just pursued, but it's directed to Bob Turner. And when you were talking about the historic context in which the Constitution was drafted to come up with this unitary theory and this extraordinary power to the president, in your view, I think you left out the important aspect of context that would have been very much in the minds of the drafters, and that was that law was understood as natural law, that man-made law was not the highest law, that there was always law above the president. And if it wasn't in the Constitution per se, the rule of law was above the president. I mean, that's Blackstone's view, absolutely, and it was Vattel's view, and if it was to Vattel, they looked for international law powers. And we get something of that in Curtis Wright as well, where the Supreme Court says that the president has to pursue our foreign policy, but it's clear in that opinion that there's an understanding that international law will limit the president, has to respect it. And of course we have, the courts had to move toward a more positivistic view of the law, but they've never relinquished that view that the rule of law is above the president. And we see, of course, in Omdi, Justice O'Connor saying the president, even in the exercise of his commander-in-chief powers, does not have a blank check. He's looking to these notions that the president is part of a rule of law system and for no purpose is above the law.
I think I agree with you, but a couple of points. One, under our system, both the president and Congress have the power to violate international law. It's been done frequently. I don't think there's any question about that. And the way the Supreme Court handles it, when Congress passes a law in flagrant violation of a treaty that cannot be reconciled with the treaty, the latest expression of the sovereign will in time, will take precedence. Certainly, the president, in his so-called plenary power, the court used the word plenary in Curtis Wright. The court went on to say that like every power of government must be exercised consistent with the rest of the Constitution. And certainly, for example, in the exercise of his commander-in-chief power, his control over intelligence, his control over diplomacy, the president cannot violate the Constitution. The Constitution is the supreme law. The Constitution was, I think, founded on a concept of natural law. I think you're exactly right. I think Jefferson talked about that in his Declaration of Independence. But ultimately, the president has to make a lot of choices. Just one sort of point of privilege to take 30 seconds. I did not start off by thanking Tom Roman, who was a legendary figure, just because I knew I had 15 minutes and I knew exactly it would take me 14 minutes and 50 seconds to get through my slides. But I also bring regrets from General John Altenburg and Alberto Mora, former General Counsel to the Navy, two wonderful people. I was with them Thursday and Friday, and they both said, please convey our regrets. They had to back out at the last minute for other reasons. And I also wanted to recognize Bill Raymond, Colonel Bill Raymond, a long-term friend, is one of the leading experts on war powers and has brought some of his Fort Leavenworth Army, not the prison side, but the Command and General's Hospital side, students to this program. And anyway, thanks.
Okay, an important point to remember is even though domestically we can violate international law, both from the executive standpoint and the legislative standpoint, it still doesn't relieve us of our international obligations and responsibilities. That's one point to keep in mind. The second point is the president actually the end-all and be-all, the sole interpreter of the Constitution under the unitary executive theory? Now, another question. Back here. I'm going to try to call upon those who aren't seated on the first two rows at this point.
Thank you. I'd like to explore further the issue of international law versus the powers to violate it. Under the Vienna Convention on the Law of Treaties, states cannot invoke their domestic legislation to justify violating their international treaties. Now, Professor Turner said that both Congress and President are authorized to violate international law. Wouldn't the honest thing then to be for the United States not to sign international treaties, or at least to make a big reservation saying unless Congress or President decide otherwise?
It's a very good question, and I agree with the spirit behind it. I think I was acting Assistant Secretary of State for Congressional Relations in 84, 85 in the Reagan administration, and I used to get outraged when I would come in at 7 in the morning and find out that at 2 a.m. somebody had put a rider on a bill going through Congress that violated our fisheries treaties or something like that. When I say they have the power to violate the Constitution, that's different. Certainly, we have a very strong moral and legal obligation to comply with all of our treaties. If we believe in the rule of law upon which we were founded, we ought to understand that anytime we violate the law, we undermine the rule of law. We also, David said I like Tom Jefferson. That's a secret, but it's out. Jefferson wrote a letter to Madison in March of 1809, just after Madison was sworn in which he remarked, "It has a positive effect on the opinion of our people and the world to have the moral authority on our side." It is so important for us, to respect the rule of law, but there are cases. We might have a friendship, commerce, and navigation treaty and get into a collective self-defense setting where we violate that because the other party is committing international aggression or something, and it's always been understood under our constitutional system that both the President and Congress can make a decision to violate the law. But otherwise, your point is an excellent one.
Okay, I'm going to assume the power of the chair here. I'd like to allow time for one more question, and then we'll wrap up. Okay.